Hello, everybody. For those of you who don't know me, I'm Jim Anaya. I'm the Dean of the University of Colorado Law School. It's my pleasure to welcome you to the 9th Annual John Paul Stevens Lecture sponsored by Colorado Law's Byron R. White Center for the Study of American Constitutional Law. I want to begin by acknowledging the Arapaho, Cheyenne, and Ute nations on whose traditional land the University of Colorado Law School is located. It's an honor to have so many engaged members of our community. Colorado Regents, Colorado Law faculty, staff and students, members of the federal and Colorado judiciary, Colorado elected officials, and other esteemed members of the legal community. Given our virtual platform, we're also fortunate to be able to welcome people from beyond Boulder and Colorado. We're grateful to have a national and international audience this year. I'd also like to recognize Suzette Malveaux, Provost Professor of Civil Rights and Director of the Byron R. White Center for the Study of American Constitutional Law, who will be leading today's discussion. Professor Malveaux is an expert on civil rights law and class action litigation. Her commitment to cutting-edge scholarship, innovative teaching, and public service enrich the Colorado law community. The law school's Byron White Center was founded with the generous bequest of Colorado Law alumnus Ira C. Roth-Gerber Jr. The White Center is an important part of Colorado Law's public service program that engages law students, lawyers, judges, and interested citizens in our nation's constitutional conversation. Each year, the center invites a distinguished jurist to deliver the Stevens Lecture. This year, we're privileged to welcome Zak Yacoob, a former justice of the Constitutional Court of South Africa, that nation's highest court, and an anti-apartheid activist. Justice Zak Yacoob, who has been blind from infancy, studied at the Arthur Blacksall School for the Blind in Durban, South Africa. He completed a law degree at the University of KwaZulu-Natal. While at the university and during his law practice, Justice Yacoob was a member of the African National Congress Underground, participated in community organizations involved in anti-apartheid and community activities, including the United Democratic Front and the Detainees Parents Support Group, and engaged in activities aimed at protecting the rights of people with disabilities. From 1973 until 1991, Justice Yacoob ran a significant and diverse commercial and general legal practice while also engaging in community activities that included defending political prisoners charged with defying unjust apartheid laws and challenging, on behalf of victims, detentions without trial, house arrest, and other restrictive decrees. He took silk, as they say in South Africa, in 1991. Taking silk is an honor in South Africa conferred by the president to advocates for exceptional skill, integrity, and leadership. He practiced as a senior counsel until his appointment by Nelson Mandela to the Constitutional Court of South Africa in 1998. Justice Yacoob is well known in South Africa and internationally for his important contributions to the socio-economic rights jurisprudence building on the South African Constitution. It's now my pleasure to turn over the virtual stage to Professor Suzette Malveaux and Justice Yacoob.
Thank you. Thank you, Dean and I appreciate that. Welcome, everyone, hopefully from all over the world. Welcome to Justice Yacoob. Welcome to his wife, Anu. So good to see you. At this time, I'm excited to begin the Stevens Lecture and the Fireside Chat. Now, because this is international, because of technology, out of an abundance of caution, we have pre-recorded the Stevens Lecture and the Fireside Chat, and we will show that to you now. We will resume live with the student questions. Thank you, everyone. I'd like to welcome you on behalf of the Byron White Center for the Study of American Constitutional Law at the University of Colorado Law School. I'm thrilled today to have Justice Zak Yacoob with me, along with his wife, Anu. I met Justice Yacoob at the Mandela and the Law Conference at the University of Western Cape 2 years ago. And he gave the keynote, and I was lucky enough to sort of corner them at a reception, to invite them to the Stevens Lecture, And here we are 2 years forward. I'm so thrilled that you could be here. Not the way we had originally planned, of course, but we'll get you to Colorado at some point. But I am so grateful that you're here during this tumultuous time. Here we are in the midst of a global pandemic, economic turmoil, upheaval from racial injustice. So this is a critical time for this conversation. And at this point, I'd like to invite you to make some initial remarks and to give a brief lecture for us. We'll then be able to spend some time doing a fireside chat, and then we'll welcome students into the conversation. So Justice Yacoob, thank you so much for being here. Anu, thank you as well.
Thank you. Thank you very much, Professor Malvo, for your introduction and for having us here. I will just take the opportunity to say that I will call you Suzette and you should call me Zak. It's a lot easier and much better.
I'm going to try.
It is an absolute honor and a privilege to be here. And I wish that I was speaking at a time when Justice Stevens was still with us in this world, but let us hope that he is somewhere watching us all. And to the computer people, it's taken a lot of time to get this organized. And I just want to say that the people who get us online these days and who get these recordings and get these Zoom sessions sorted for us properly are as important as the caterers were in those days. But I want to say 3 things today. The first thing I want to talk about is how I grew up and how I got to where I was in relation to the law and what shaped my attitude. Because I believe in the notion that we are who we are and we cannot see things through anyone's eyes except our own ultimately. And it is those eyes that I want to try and describe to you. I grew up in a religious family. My father was a priest in the mosque in a village. I grew up in very strict circumstances where everything had to be done to the key, where Islam was regarded as the best religion in the world, where everyone else was regarded as an inferior, and where after which I had to go to a school for the blind, where I was the only Muslim student present, and where I began to understand that Muslims were really not so superior. That in fact I had been taught wrongly at home, and that life was a little bit more different. And I began to understand that everyone was a human being. Not without a struggle, because the first year or 2 of being there was really complicated. I did ridiculous things like standing up on my toes and finding a corner of the town at which no Muslim would have wiped their hands or their faces before I touched that part of it. But thankfully, that changed slowly. And the importance of religious principle, the importance of honesty, the importance of humanity struck me. But I want to say that despite all that, when I left school after 12 years there, I was still a racist and a sexist. I believed that Black people were inferior. The only Black people I had met were gardeners and so on. I was Black too, but I thought that we were Indian, and if we tried hard enough, we could be as good as the white people were. And I thought that Black people could never be as good as we were, until I went to university in 1967. And when I got there, the university had a policy in those days that white people who were not worth their salt would be sent to teach at bush colleges or institutions meant to teach only where Indians or African people or others were. So I went to one of these university colleges, and there was a white lecturer I had at my first lecture, and I had thought until then that all white people were wonderfully clever. And then suddenly here it was. There was a white man lecturing to me who was absolutely stupid. And then I met Black people who were cleverer than I was, and my eyes began to open. And the road toward non-sexism and non-sexism was slow and hard and difficult. Non-sexism was more difficult. It is much easier to proclaim racism or to proclaim non-racism rather than to really believe it and feel it and think it and live it. It was very easy to proclaim non-racism and non-sexism, but the rest was a bit difficult to get to. So that's the first point I want to make, is that we all grow, and we must not be unhappy about growing. We must not be unhappy about learning. We must not be unhappy about learning to be different. I feel a bit embarrassed about how I was then, but it's not too bad. The second point I wanted to make is that I then, at university, joined left-wing socialist circles, as many students do, reading Karl Marx and Marcuse and all sorts of things, with students reading to me. And then, as a result of my change and the effort to become a non-racialist, I became very early a part of the underground of the African National Congress at the university, and became part of that underground, and began to learn to organize and mobilize people, and began even then to understand how we need to organize and mobilize, how it was important to ensure that raising people's consciousness was important, talking from a platform was less important, and making sure that being at people's sides through things that they experience was the most important of them all. So I got to practice as an activist already. And there came the start. Now, I was a blind person at practice. Everyone thought that blind people were stupid, with the result that it was very difficult for me to get work initially. And it was important then to do free work, because what free work did for me was that it enabled me to ensure that I got an appearance before the courts and people saw me in action. And it was that free work that got me into action. And it was that free work which got me actually to understand that it was the law which was important in the course of shaping a struggle for democracy, but the law was not all. So we used, while I was at practice, with all activists at our disposal, began to use in 1973 already, 2 years before Justice Stevens went to the Supreme Court, we began to use law as a weapon to achieve democracy. But we soon began to understand that law is not the only weapon, that there are other weapons for the achievement of democracy, that the fundamental weapon is the organization and mobilization of people, the raising of people's consciousness, activism, sacrifice, movement, expressing one's views, and making sure that the hearts and minds of people are changed. We soon realized that law was only a secondary objective. That's the second point. And the third point, which I'll do quite quickly, was that with this background, I then continued to participate in the struggle and continued to come to the Constitutional Court, thinking that the Constitutional Court was perhaps the weapon in creating a new society. I was disappointed in that too, because I began to realize while in the Constitutional Court that again, law was not the only weapon. We did what we could. We gave the best judgments we could. But unless we change the approach and the attitude of society at large, nothing is going to work. So, for example, the Constitution says that all of us are equal. Many people in our society believe that we do not. For example, the Constitution says that gay and lesbian people are equal to all of us. And of course, the Supreme Court, our Constitutional Court, also says that we are all equal and that gay and lesbian people should be able to get married. But 90% of the people in our community say gay and lesbian people who are married in sin. So 3 points there. 1, we all grow and we all are sometimes sexist and racist at heart. We've got to change. 2, law is a very important weapon in changing society and we ought to use it as best as we can. And law is not only about making money, because if you do free work, you can gain a great deal more. And thirdly, and the final point is, law is not the only weapon. We can deliver all kinds of wonderful judgments, but in the end, we've got to ensure that our consciousnesses are raised. So, Suzette, I hope I've given you enough to go on.
Yes, thank you. I appreciate that. And so powerful and inspiring and insightful remarks. You know, I'm so glad, just a couple of initial sort of reactions, but I really appreciate you reminding us of the importance of us being human beings and being works in progress. Not being ashamed to say that. We have so many really good legal scholars these days who've done some work about systemic racism, institutional racism, unconscious bias. And so, you know, realizing we're all human beings and we're all working on this. So I think that's an important reminder. I share with you the thought, the perception that law is not everything. It's a piece of a much more complex puzzle that we're all still trying to figure out. And that, you know, the best, in some ways, you know, law is aspirational, and sometimes it's ahead of us and sometimes it's behind, right, when it comes to our values. You know, when we think about Brown versus Board of Education, it might have been a moment in our country when the law was a little ahead of everybody in society. And there have been other times when the law has had to catch up. So, for example, marriage equality. So all of that, I just really appreciate that. And I think I'm reminded. I'm going to talk. Hopefully, we can focus a little bit on the Constitution. But I'm reminded of the importance of you know, learning from other people. What can we gain? What can we learn from others? There's a certain humility that comes with that, with recognizing we're all works in progress. And there's a book by Mark Kende, Constitutional Rights in Two Worlds. And he tells this amazing story about Justice Ginsburg and how she came to South Africa in 2006, gave a speech. The building was new for the Constitutional Court, and they were literally celebrating the fact that it was on grounds where a prison held Gandhi and Mandela. And she told this story to the audience, and she said that she had actually received death threats for relying on foreign law in her opinions. And in contrast, the South African Constitution requires that the court follow binding international law and encourages consulting relevant foreign law. So I wonder, Justice Yacoob, if you can speak to the relevance and importance of foreign law, learning from other courts and learning from people throughout the world.
Thank you that you mentioned Justice Ginsburg on that.
Yeah.
She was at the Constitutional Court in 2006.
Yes.
And she was a wonderful speaker, and she delivered a paper there and at a few other places in South Africa. And one of the important points she always made was focusing on Section 39 of the Constitution and making it quite clear that our constitution makers were right in ensuring that international law and foreign law were resorted to by our courts. Section 39 of our Constitution does two things, as Justice Ginsburg also pointed out in her address. The first thing it does is that it provides the court with an opportunity to consider foreign law, saying that any court considering any constitutional matter may consider foreign law. But going further in relation to international law, so the United States law would be foreign law, and international treaties obviously would be international law. But in relation to international law, we are obliged to consider international law, not just given the discretion to consider it in our country. Both are extremely important. We have done both, but we have referred to international law much more than we have referred to foreign law. We have, for example, referred to international law in the context of making it, we have to decide, for example, whether in a particular case, whether a soldier was a worker. And we referred to international labor law instruments in coming to the conclusion that a soldier was a worker. The important thing about this is that we begin to understand, as Justice Ginsburg pointed out, that we do not live in a vacuum. that we live in the world. The world is becoming a smaller and smaller place, and we have got to learn from each other. And it was recognized by many Americans and by Justice Ginsburg long ago that you cannot be isolationist. And I want to say that even the United States of America has changed a great deal. When I went there in 1986, it was very, very difficult for me to find somebody who was against the death penalty. They all thought I was sort of half insane. Now, of course, I'm happy to say that when I go to your country, I find many, many people who are against the death penalty. But it's an understanding of the principle that we learn from other people, that we have to keep ourselves open, that knowledge is not limited to ourselves. It is a proclamation that we will not be arrogant in our thinking. And it is actually a movement towards a single world. It's a movement towards our society, which hopefully we will reach one of these days, in which we will truly be able to say, not only imagine, but we'll truly be able to say that there is no country.
Thank you. Thank you. I agree. I think it's the importance of learning from other people is so critical. You know, I want to go back to the idea of you mentioned the South African Constitution of 1996, and you know that Constitution is known as probably the most progressive, comprehensive constitution in the world, right? Because of the breadth and depth of rights and protections are really unparalleled. So, you know, you look at, you know, it has the rights. So, for example, United States, our Constitution rights like, you know, equality, religious freedom, privacy, reasonable search and seizure. But then also in the South African Constitution, you've got rights to food and water and housing and a clean environment and healthcare and education and fair labor and court access. I mean, it just goes so far, so much farther than what the United States Constitution does. And when you think about just the categories of protection, again, we have race and gender, but the South African Constitution goes beyond that. So you have sexual orientation, pregnancy, disability, cultural communities, even immigrants. So I wonder, what can we learn from your Constitution, and do you see it as a model for others?
I don't actually see any constitution as a model because life is dynamic. It changes all the time. We continue to learn and things continue to change. Certainly, it is a document worth looking at for anyone wanting to draft their constitutions. As for example, your constitution was worth looking at when we drafted ours. It was certainly worth looking at. As far as the Bill of Rights was concerned, of course, we adopted the Canadian model, which was the justification model, not the United States model. But nevertheless, we had to look at it. So there are three things one can say about that. The first is that a constitution is as good as when it was produced. So if our constitution was produced in 1786, for example, it would have looked very, very different to what it looked like when it was produced in 1996. And let me say this, that by 1996, academics were beginning to talk a great deal about gay and lesbian relationships, beginning to talk a great deal about ensuring that things were better at that level. And no constitution drawn in 1996 could begin to say that gay and lesbian people were not true human beings. And I'd like to make brave to say that even 20 years earlier, a constitution could have said that, bearing in mind what was prominent in terms of ideas in the universe at that time. So the first point to make is that a constitution is a product of its time. And if I were to write a constitution today, I think it would be different to the constitution I wrote then, because years have gone by and things are very different. Second thing I want to say is that the constitution is a product of what it came from. Yours was a product of the Civil War. Ours was the product of a struggle too. It was a product of a struggle for democracy, a struggle in which gay and lesbian people took part, a struggle for equality in which Black and African people took part, a struggle for equality in which labor took a considerable part. And therefore labor, the gay and lesbian community, poor people, all of whom participated in the struggle, were very important stakeholders in the Constitution and had to be taken into account. So that is the reason why, for example, the protection of gay and lesbian people is included in our Constitution, because that was what the thinking was at the time. Now, why are labor rights included in our Constitution? Because labor struggles were very important in achieving our constitutional order as distinct from the United States of America when it was not so. Why then were social and economic rights included in our Constitution? Because socio-economic rights were important to the majority of people in our country, and if the Constitution was to serve the majority, social and economic rights had to be included. But then the question is, why were they included in the terms in which they were? And the answer there too is quite simple. That before 1996, about 40 years earlier, academics talked of first, second, and third generation rights. They said that first generation rights were civil and political rights, second generation rights were social and economic rights, and they said third generation rights were environmental rights. That sort of separation existed. But by the time our Constitution was written in 1996, academics and all of us had educated ourselves into beginning to understand that all rights were interrelated. They were so interrelated that if you have no money and no clothes and no food or water, no water, talking about exercising your right to vote is actually quite nonsensical. So ultimately, our society had developed to the stage where those rights had to be included, and our Constitution is a product of the time. And while I'm speaking, I must say that there are two kinds of provisions. The one provision in our Constitution is to ensure a kind of regular democracy. The first kind is the second kind rather, is the reconstructive provision of our Constitution. What that does, all these provisions like socio-economic rights and labor rights and so on, ensure that these provisions provide a platform for us to continue to struggle to achieve the constitutional vision. So there are some things that the Constitution does now. There are other things for which our Constitution forms a launching pad and obliges all of us to continue towards working towards its vision. And I suppose that the United States Constitution can also be interpreted in the same way.
We hope, we try. You know, I think it's interesting about your Constitution also is that you have freedom of press, you have freedom of expression, you know, very much like the First Amendment in our Constitution. But there is not a protection for the advocacy of hatred, right, based on race or ethnicity or gender or religion. And there's also a guarantee in your Constitution, a right to dignity. Why is that so important? And how did you strike the balance that you did, the relationship between those rights?
I suppose that in 1996, we already began to realize what Justice Stevens was beginning to realize. Because you will recall that by that time, he began to understand that freedom of expression was subject to qualification, that freedom of expression was not equivalent to money, that companies could not exercise their right to freedom of expression to achieve a whole range of things. We just took, I suppose, one leaf from that book and came to the conclusion that freedom is subject to qualification. And that for us, bearing in mind the fact that the dignity of so many people was affronted in the past, bearing in mind that equality was so much trampled over as a result of the licentious exercise of freedom in our country, that for us, dignity and equality were important. And the debate was, which was more important? And we finally came to the conclusion that they were equally important. We came to the conclusion that our constitutional values have to conform with both dignity, equality, and freedom. So, as far as I'm concerned, because freedom is mentioned last, for me and my own personal view, I would suggest, and there's no constitutional court case which is saying that, but as a retired judge, I claim the liberty to say that I would any day qualify freedom of any kind, even freedom of expression, to achieve equality and dignity. In fact, I would qualify freedom of expression more easily for dignity and secondly for equality. But of course, on the understanding that equality and freedom are interrelated. Mm-hmm. So I would say that they're a complex set of values. And I would say that even now, many countries are beginning to understand that licentious freedom is not what we are talking about. The United States laws of libel make it very clear that dignity is also extremely important. And I would suggest that in a universal rights syndrome, if we began to subject equality and dignity to freedom of expression and to any other freedom, we would not be doing badly.
Yes, thank you. I'd like to turn our attention to talking about judging and the role of courts. As you know, we are in the United States are in the midst of selecting a Supreme Court justice. We just had confirmation hearings last week of Amy Coney Barrett, and our process has become highly politicized. Last year, when I did the fireside chat with Justice Elena Kagan, we talked about, at one point, she had described the process as a vapid and hollow charade. So fast forward, that was a while ago, but fast forward, many people in our country are losing confidence in the judiciary as an independent branch of government. Can you talk about the confirmation process in South Africa and what role that politics play, if any, in the selection of justices on the Constitutional Court?
The first thing to be said is that there's no perfect process. What is absolutely clear is that the executive appointing the judiciary or the legislature, any of the legislative branches of government appointing judicial officers by themselves just doesn't help you. Because ultimately, more and more judges decide on the validity of legislative or executive conduct. And therefore, for you to choose your own judge in these circumstances doesn't really help. That's all I want to say about the confirmation system, because on that basis then, the confirmation system is always going to be subject to trouble, because when the Democrats are in power, they'll have their people. If the Republicans are in power, they'll have their people, etc., etc. There's absolutely no way out of it. That is the reality. You can preach for as long as you like, but you are not going to get anybody adopting a different approach. Of course, some political parties go too far. I would imagine that Obama may not have pushed a new judge into the scenario just now, but I don't know, Suzette, whether I'll be prepared to bet on that one. Mm-hmm. But leaving that aside, we need different kinds of mechanisms. We have a mechanism of 25 people, consists of representatives of the judiciary, representatives of the executive, representatives of the legislature, of the lawyer's profession, and to a degree of civil society. You can make that calculation in different ways, and you can work out different people having different influences in the way in which they do things. But it is the most flexible appointment mechanism I have come across. But the mechanism has to do more than with numbers. What the mechanism has to do is to ensure that we set out very clearly the guidelines which we would use to determine whether a particular judge should be appointed or not. And I would imagine that the determination of appropriate guidelines might be useful even in countries like the United States, because if congressional hearings are constrained by guidelines, it might be useful. The problem is that the guidelines might be considered to be too limiting or not too limiting. So my answer to the question is that A, the executive and or the legislature appointing judges in this day and age doesn't meet the bill at all. That no legislature, whether liberal or non-liberal, can be expected to act independently and openly and fairly, because two legislatures and two members of political parties, there is an absolute link between fairness on the one hand and the approach of the political party concerned on the other. So we've got to take it out of the hands of the executive and the legislature as much as we can. But secondly, and more importantly, we should have guidelines which indicate what judges should or should not be. And if we have a set of don'ts for judges, for example, judges who have been shown to be racially discriminatory directly or indirectly in any way should never qualify. Judges who've been shown to be sexually discriminatory or something ought never be able to qualify. If we carefully develop guidelines which must be adhered to and limit the extent to which opportunists can rely on interpretational difficulties, we might actually get there. But it is a very difficult problem. It is work in progress. We'll never reach the ideal, and hopefully we'll get there as time progresses.
Yes, and I think, what's interesting right now is that there are a number of reforms that are being talked about in the United States in terms to the Supreme Court. So term limits, whether or not we have more judges, more justices. I know you have 11 on your constitutional court, and you also have term limits. Do you think having a term limit is, what are some of the pros and cons? What's the rationale behind having a term limit? We have lifetime appointed justices. What are some of the pros and cons of that?
I actually don't think that term limits do really work, because then sometimes you lose people too easily and things happen too seldom. Nor do I think that death ought to be the way by which things ought to be determined. And I think also that judges themselves deciding when they should retire doesn't really help us. I really think that an age limit is the absolute answer. Those age limits would change as time goes on. And I would imagine that when I was on the bench 10 years ago, 75 was the right age limit. And of course, we've got to get some expertise on this matter, because people know when people remain ordinarily, human beings remain able to perform their mental functions properly. I would imagine that today 75 is about the right age. 80 would be the absolute upper limit. But I think that somehow we should determine every 5 years, through the exercise of expertise other than lawyers, what is the appropriate age for people to retire as judges. That retirement age should be set, with that committee of experts having the final say about the age when they set it. The judges should be compelled to retire at a particular age when experts have determined that they will not be able to offer their services. And you cannot leave it as subjective, because that may be wrong. It may be wrong in half of the judges. It may be right only in a quarter of the judges. But nevertheless, you can't leave it to the subjective whim of particular judges. An objective standard would be to determine some kind of retirement age by people who have the necessary expertise to do so.
I'm sure you would get pushback, right, from some of the elder justices. And I know yourself, you felt like you were off the bench too early, right? 15 years was not enough.
No, absolutely.
Point. Yeah. Absolutely. So it's a hard question to sort out. I know you have 11 justices on the court. I imagine lots of disagreement, lots of different viewpoints. Can you talk a little bit about how you come to consensus? Under what circumstances do you decide to dissent? And what you think the role of dissent is?
Okay, I can tell you what the position used to be when I was at the court, because things continue to change, because these are dynamic and difficult circumstances. When I was there, we understood, 11 of us, that we had to learn from each other. We came from different backgrounds. We understood that truth and the notion of truth, if it existed at all, was an extremely difficult proposition. And that what is right or wrong was even more difficult. That context was equally important, that everyone saw context differently, that everyone saw the world through their own eyes. And therefore, the only way to put things together is to put all our eyes together, put our hearts together, and talk carefully about things to try to agree on as many things as we could agree on. Now, that approach worked well. It does not eliminate dissent, but it does, for example, leave out dissent and avoid it in certain circumstances. So you would find, for example, in some of my judgments, things that I would not have had there, but I would have put them in because they would square with the rest of everything that was there, and the judgment would work. But more importantly, if one adopts this approach in an open-minded way, I always found that listening to other people made me wiser, made me understand things better, made me see something that I never saw before. And therefore, all the judgments that I have written, even some of those that I've been praised for, I can never say I've written alone. They have always been the result of consultation. What happens in the normal course in those days, was that we drew judgments. There was a draftsperson indicated by the Chief Justice or the President of the court. The first draft was done. And then everybody made comments. Comments were received. The draft person thought about those comments and sent a second or third or fourth draft, as the case may be. Ultimately, there was a conference at which things were discussed, and the dissent was resorted to only after all those processes were gone through, and only after it became clear after those processes that nothing more could be done to achieve consensus. So it was very important to consult carefully, to listen to everybody carefully. And you won't believe how different the first draft of judges was, issued sometimes a week or two after the judgment, to say the fourth draft, which came 5 weeks later. Sometimes you would not even recognize the draft as being that of the same judge.
And at what point does, when the role of dissent, I mean, at some point there's that consensus and you get there, but when do you think it is important actually to stand alone in a decision?
Yeah, well, firstly, I would have a dissent only if I thought it was absolutely essential to have it. And if I had to stand alone, then, and that was too bad. It's not standing alone that's a problem. It's not the dissent that's a problem. I think that a dissent is a very, very positive thing. The only qualification is that a dissent must be resorted to only when there is no option. So when there is no option, a dissent is essential. And then one would say that the dissent of today is the majority judgment of tomorrow, because a dissent very often contributes to what happens in the future. But there's one more thing. There are too many judges who write concurrences. Concurrences are unnecessary if the scribe is flexible enough to incorporate the concurrence or the views of the concurrent judge in their judgment. I have done that very often, and that makes reading of the judgment easier, because in the end, and that's where we succeeded a little bit some years ago, but now we've not succeeded. The US, I think, has not succeeded. Judgments have to be accessible and comprehensible. And if a human being has to plow through 6 or 7 judgments with all sorts of, shall I say, so-called complicated ideas, because these ideas are not necessarily complicated. They are really made complicated because one wants to fuzz the issue. I think that in 99% of the cases, you can always break things down to their absolute essence and write things as you want to write them. I remember there was an expert report which we had in a case where somebody had been injured in a motor accident. And he said in his report that there is no dysfunction in the mandibular region from a masticatory point of view. All he meant was that he can chew properly.
Wow. Very complicated. I see the point. Point made.
Rather, there's no function, there's no dysfunction in the mandibular region from the masticatory point of view.
That's painful. Yeah. I think sometimes we overcomplicate things, and I think it is important to make opinions accessible to people, right? So, they understand these opinions. There's some beautiful writers on the Supreme Court who've done a masterful job of bringing to light and making real, what these opinions say and why they matter. We talked about that last year with Justice Kagan. There have been some real masters. I think Ginsburg's another one of those people, just beautiful writers, and makes it accessible to people, which is really important. I
won't mention the name, but it's always complicated when a judge you disagree with fundamentally writes beautifully.
Yeah, there are some of those too. I want to turn our attention to racial justice conversation. We are in the midst of the largest civil rights movement since the 1960s in the United States. Black Lives Matter has catalyzed a major racial justice movement across the United States. And there's always been this really interesting symbiotic relationship between South Africa and the United States in terms of fighting racial oppression, right? Understanding it and fighting it. So for example, international pressure was critical to dismantling segregation in the United States. And activism in the United States was influential in dismantling apartheid in South Africa. So there's been this real interesting relationship. I recall, and I'll just share a little thing about my own activism. But when I was a college student at Harvard, we had pushed for divestment out of South Africa. We brought Jesse Jackson on campus to come speak to about 5,000 students. We held protests. I recall I took a big white sheet and I spray painted on that sheet, "Divest Now," and hung it outside of the window of my dorm at the top of the floor in the middle of Harvard Yard. So I still have that sheet in my basement. But, you know, it's something that we, you know, there's been this real passion and dedication kind of on both sides to play some role in terms of pursuit of racial justice. And, you know, I thought it was very interesting. I'd love for you to tell us a little bit more about your own activism, which you had mentioned in your initial remarks here, and how you ended up joining the Underground ANC. What was that like for you? What were some of the kinds of things that you did as a young person?
Initially, it was not big and serious. It was a lovely, exciting thing to do. It felt wonderful to say that you can only recreate society after you break it all down completely. It is also miserably bad. And one thought one was saying wonderful things when one said that. And initially, I think it was first the excitement of being at university, being able to make a change, being able to participate in communal life. And there was some passion in being able to say that adults were all completely wrong. So that was what all started this in the end. But then slowly it became a lot more complicated, a lot more difficult, and one had to deal with one's own sexism and racism. I had to deal with my own religious beliefs because I slowly began to understand that religion was a little bit problematic for me personally. That was a long development too, because as I said, my father was a priest, and I once was, for some years, between the ages of 30 and 40 or something, the kind of atheist who rejected everyone else. But I soon got to the stage where I now accept everybody. And I think that some people belonging to certain other religious groupings may be a million times better than I am as a human being, and that it depends on our humanity and what counts and what happens. So religion was a very important thing for me to work through. Sexism and racism were important things for me to work through. And I suppose it helped that as a young Muslim student with a priest as a father, the two of us that fell in love were Anu and I, a woman who belonged to a Hindu community. And you'll see from the politics of India how Hindus regard Muslims these days. And there were Hindus in South Africa who regarded Muslims like that. There are also Muslims who regarded Hindus badly. And our marriage had to be very carefully negotiated and delicately so. And although we understood each other carefully, merging families and talking to each other and so on in South Africa was a very difficult thing. And I think that it was that relationship, it was learning to live together, because no doubt about it, in the end, the way you were brought up did come in the way in the first few years. And learning to live together was an extremely important part. And it was that learning and the fact that we had our children, which made a very big difference. I remember when our daughter was born, thinking, oh my God, what would I do if she is a lesbian? And that's what drove me much further along the road towards accepting gay and lesbian people. And then I said, oh my God, if my daughter marries and people treat her in the way in which most men treat women in our society these days, and I will not say anything about the extent to which I was guilty, what is life going to be about? So the birth of our daughter really helped me a great deal. The birth of our son also helped me a great deal, because another new kid at a different time. So the family was extremely important to me. And it was in the end, being in the right place at the right time and being committed to ensuring that I did well for society. I didn't ever want to be a judge. That never really occurred to me, although once it became a reality, it was a very exciting proposition. I did what I did. If I was asked to help in the negotiating process, I did that. If I was asked to be part of the election, I did that. And my whole philosophy was that I would do everything that I undertake to do to the best of my ability. Sometimes, of course, the best of your ability is not good enough, but I am very happy to say that the best of my ability has been good enough for about 90% of the time. I would not like to talk about the other 10%, but 90% is not a bad showing. So yeah, I think that's what I would say about that.
Yeah, and I appreciate, again, you kind of talking about your own growth and that journey, that process is so important. You know, I think so many of our families that we've come, we know that we love and respect people of all different sexual orientations and races and backgrounds. And so I think that this is, you know, I think it's, you can't say it enough, right? The importance of growth and change, and that's okay. It's very brave. And so I appreciate you raising that again. You mentioned that you had worked for the Electoral Commission. You know, we're in the midst of election coming up, and our United States has a long history of voter suppression, which continues today. And I wonder for you, what was that like for you to work on the Electoral Commission, to be responsible for setting up the first democratic election that was fair and it was inclusive? And if you can talk a little bit about the influence Nelson Mandela had on you when you were appointed.
That was a very special election. It was the first election in our country. And there were 17 people, 6 people from other countries and 11 people from our country, who were entrusted with the task of conducting the election. 1 or 2 people were members of government representatives in the past. The chair of the commission was Judge Johan Krichler, who later ended up on the Constitutional Court and who was on the appellate division at the time and who became a very, very close friend of mine. And of course, Justice Moseneke was also on that commission. Judge Moseneke was a deputy chief justice of our country in New South Africa, and I was there. It was a lot of hard work, but it was shortly after I was approached to be appointed that Nelson Mandela asked to see me, and I was merely 36 years old then, and he called me boy, and quite rightly so. And he said, "Boy, I asked you to come and see you for a reason." So I said, "No, thank you very much. You do honor me," and so on, to ask me to be part of the election. You can rest assured that I'll do the best I can, and so on. I made such humble comments as I thought were appropriate, and such comments as I could in that presence. But he said, "Boy, that is not the reason why I called you here. I called you here to give you an instruction. I know that you are a disciplined member of our movement, of the African National Congress. And what I want to tell you is that I appointed you not because you're a disciplined member of our movement. I'm appointing you because you are independent. I want you to be independent. My instructions to you are not to take our part." And those were absolutely amazing instructions to receive, which no leader could give to anybody ever.
Wow, that says a lot. I mean, that says so much about his character. You know.
Yeah.
Yeah, that's so inspiring. I was hoping you would tell us a little bit about your reflections with Nelson Mandela. I've not had a chance to meet him directly, but I remember when he was first released from prison after 27 years. And I was living in Zimbabwe at the time, volunteering for an NGO. And Zimbabwe was one of the first countries that he visited upon his release. And, you know, I can tell you just the energy was palpable, right? Just being able to see him at that time period. So amazing. I wanted to turn to maybe some personal reflections, if you don't mind. Maybe it's personal. You've already opened up tremendously about sort of your upbringing and your transformation when it came to race and dealing with racism and sexism and sort of doing your own work, which many folks are trying to do, especially in the United States. I think many people are going to be going home for Thanksgiving and really sort of challenging themselves and challenging the ones they love to think differently. I want to turn our attention, though, to your eyesight and ask what impact, if any, has being blind had on your values?
Well, a couple of stories about that. I became blind when I was 16 months old, so I don't know what it is to see. Mm-hmm. And I realized that I was different from others. Only people told me so, and I began knocking into coffee tables and so on and so on. But I was treated at home like an ordinary kid. I was disciplined like everybody else. I was not spoiled. I did what I was asked to do. And one story has to be told about that before I get to more serious matters. I was asked never to cross a road on which motor vehicles were. So we lived in a central street in a little village. It wasn't too busy. There was a wedding opposite the road, and I was sitting on the lawn on one side, and I listened carefully, and there was no traffic. And I crossed the road and went home that evening at the age of 5 or something, and boasted that now that limitation does not have to apply because I had now demonstrated that I could cross a road. And of course, you know what happened. One was severely chastised for those things in the past, for cause a good hiding would only cure you of that sort of conduct in the future. But blindness was something which I accepted. It was normal. When I was at school, I was a good student at school, so that was good. When I was at university, I was a reasonably good student. I was able to explain things to people, to my co-students, so that worked very well because people would be very happy to come and read to me, because the quid pro quo was that they would read and I would explain and we would discuss, and we got on famously well together and so on. And I'd make sure that those students were richer than I was, so they bought the Coke and so on. But that's a slightly different issue. And then I went into practice. And the problem there is that people think that when you're blind, you can't think. You've got no brain at all. So they don't send you any work. And therefore, the thing I had to do was to do free work and to prove that I can do work and so on and so on. To be involved in it. The advantage, though, that I was the only blind person in the ANC underground. So I was treated like absolute gold. I was an exception, and I sort of enjoyed being treated like gold. The other advantage is that people are very helpful when you can't see. And of course, the advantage also was that I think that police people in every country have their problem. In the same way as they could not believe that African people could do great things in this country and could form an underground, that could form operations from outside the country. And in the same way, as I have no doubt, that conservative white people in your country believed and still believe that Negro people have a deficit. That was a deficit. Black people have a deficit. And that deficit too, African American people, and that deficit too has a bit of a trouble for them, because the police could not believe that I'd be in the underground and so on and so on. And therefore they never caught up with me. I was never detained. And of course I was taught, of course our home was searched once, and because I was blind, there were no documents at home. What does a blind person need documents at home for? And I remember I was quite an arrogant fellow in those days. I hope I'm not anymore. But I remember the police asking me where are all the documents, and I arrogantly touched my head. So that was my experience as a blind person. It was hard to get work. There were pros and cons. But in the end, I am who I am. I'm happy to be who I am. And I had to choose to be an advocate, a barrister in English terms, instead of being a solicitor or an attorney. And that is because when I qualified, I went to 30 or 40 attorneys. You had to have articles with an attorney who had to pay you money for articles before you became an attorney. And you had to be with the attorney for 2 years. 30 or 40 attorneys all said to me, "Oh, you are such a wonderful person. We are so proud of you. You've been so excellent. Despite your blindness, you passed your degree. If only we had space, we would have you. We are so sorry. We have no space." And that is the reason why I could not be an attorney. I said, okay, I'll be an advocate then. But many of those attorneys paid for it because they came to me later when I was beginning to be a success and wanted to give me work as attorneys. And I said, oh, they don't do that until they first admit that they lied, they had no safe space, and until they apologized to me. So I got my own back. There's lots of ups and downs, but I think it's very hard. It's very difficult because you have to be hard and cheeky, almost impertinent and difficult to survive the sighted world. And the problem about that is that then you start adopting those same attitudes to your own family and to your own friends, which is not necessarily a good thing, which is not a good thing, not necessarily, but not a good thing at all. And therefore what happens is that that kind of conduct, which is aimed at making you acceptable to other people in society, and I've done that sometimes to my embarrassment, replaced or conducted myself in that way with people who love me and who care for me, which is quite wrong, but sometimes it happens, and that's a slight complication.
Yeah, sure. Do you think it has made you more empathetic?
Did I?
Did it make you more empathetic?
Oh yes, it made me much more empathetic. It made me understand people's weaknesses, but also it made me understand more clearly than anyone could understand how irrelevant the color of the person's skin is. Because what you don't know is actually quite irrelevant. So I don't know. I mean, I don't know what color your skin is. I don't know how you look or anything. And it's very interesting because Anu used to ask me when we were much younger, oh, she was a bit worried about what I think of her if I suddenly were able to see. And I said, I hope I'll still be the same. I hope that how she looks doesn't matter to me in the least.
Yeah.
So appearances don't matter, which is very nice. Sometimes I overdo it and say to the family, I don't care if I have food on my clothes, I won't change it until tomorrow. But I'm trying to be a bit more careful.
Thank you. I'm sure Anu appreciates that.
Yeah.
You know, and I know at one point you had the opportunity to have surgery and perhaps gain your eyesight, and you opted not to do that. So what made you decide to go in that direction?
I didn't go in that direction because my optic nerve has been damaged from the time I was 16 months old. And the brain centers in relation to vision develop from the time you're 6 or 7 months old until such time that you reach 23 or 24. So my brain centers stopped developing at that level when I lost my sight. And they say also that those brain cells began to be used for other purposes. Maybe there's some truth in that. But the brain cells in relation to vision have not developed. And I know the optic nerve can be repaired now. And I know many people who wanted to go for surgery and who have been for surgery, who've had trouble with it, even when they're 50 or 55, because the brain has to learn to see all over again. And as far as I'm concerned, I have my identity, I have my life. I've learned to live as a blind person rather. I do not wish to learn to see again. I do not wish to live as a sighted person again. My life is complete. I don't want the trouble of an operation and learning something completely new. I'm happy as I am. Some people will call it cowardly, but well, there it is.
No. Yeah. Just perfect the way you are.
Okay.
A fun fact, I know you love cricket and you are serving on the International Cricket Council. What do you do on the council and what is it about the game that you love so much?
What I love about by the way, I love baseball too.
Okay.
I have been to a number of baseball matches in the UK and some teams in the US, and some teams have given me a ball initialed with their names and so on, which is quite nice, which I have at home. And the nice thing about both those games, as distinct from, say, American football or soccer or rugby, that in those games, lots of things happen at the same time. Even in a horse race, lots of things happen at the same time. In a game like cricket, there's one ball, it is thrown, something happens to it, somebody reacts, and ultimately only one thing happens at a time. So you don't have to have your eye or your concentration on 2 or 3 parts of the field at the same time. And I think that is what makes me and many other blind people warm to cricket. There is such a thing as blind cricket. I don't know about the United States, but we have a blind cricket team in South Africa. We have one in the UK. I'd be interested to know whether there's a blind baseball team in the US. It might be. The rules are slightly different. They use balls with bells in them and so on. And there are somewhat different rules, but that actually happens. But really, I think cricket is the game where one thing happens at a time. So people like blind people who have limited brains don't need to concentrate on too many things at the same time.
It sounds like you have a great time on that council. It was a good game. I'll have to watch it. I'm not, know very little about it.
Oh, the International Cricket Board, I'm one of the judges.
Yes.
And what they have is a panel of judges, and each country nominates a judge. And then somebody chooses who takes part in a particular case as a judge, provided that your country is not involved. So nothing happened for 5 years, and now there's some debate in a particular country, not South Africa, about whether a cricket official tried to bribe the sports minister there. And it's supposed to be all confidential. And I will be participating as one of 3 judges in judging that case, hopefully in the next 3 or 4 months in some part. Oh, it will be in Dubai because the ICC's offices are in Dubai, which I thought is quite fascinating. So that whether you're from England or India or Sri Lanka or whatever, or Zimbabwe or South Africa, Dubai is easy to get to.
Oh, nice. Okay. Hopefully people, I don't know if people will be traveling then, but coronavirus, of course. But it sounds like fun. I'd like to focus a moment on the young people. South African political parties are focused on the born-free generation, that is, those who were born 1994 and afterwards, and that they comprise 47% of the population and 14% of the electorate. Similarly, in the United States, political parties are reaching out to millennials and the Gen Z. But when it comes to participation in elections, about the senior citizens, the older folks, come out about 70% voter turnout. The younger generation, only 46% voter turnout. So there's some work that is being done around that. What do you see as the role of the younger generation today in terms of shaping South Africa's future and combating the legacy of apartheid?
Well, quite obviously, it's the younger people who shape society, and they should always have a say in ensuring that society does work well and ensuring that they make their contribution, because the future of young people lies in the future of the society in which they are. And in fact, by making society better and ensuring that they make their contribution now, they are making their lives in the future better. So I want to say to all young people that life is not only about making money, it is also about doing something to make society better. And if you make society better, your life is better in the future. And I would like to say that society is not only about material enhancements. It is about humanity. It is about dignity. It is about human beings. It is about suffering. It is about freedom. It is about the avoidance of poverty. And what one needs to create, ultimately, I would say to all young people, is an international order, a world in which we all believe in the humanity of each other, and all of us make a contribution, not only toward ensuring that we lead a good life, and I agree that we must lead a good life ourselves, otherwise there's no point to it, but we make our own contribution to doing what we can towards avoiding suffering. And in my view, participation in politics and elections and getting the political parties right is one way of doing so. But I'd say that you've got to be a good human being first. Whether in the end you end up being a politician or a Democrat or a lawyer or a judge, I would like to say to all young people that you've got to be a good, empathetic human being, sympathetic with other human beings first, before you can be a Democrat, before you can be a good lawyer, before you can be a good participant in the struggle, and before you can be a good judge. So I would say to all of us, let us all cultivate our humanity and let us do the best we can. And I'm quite sure that if all young people bear in mind their own humanity and the humanity of others, and they do their best to the extent that they can, that is all we need, society will not suffer. Society will suffer only if we reach the stage where more and more young people stop doing their best. Some people believe this would happen. I'm an eternal enthusiast. I don't think it'll ever happen.
Well, thank you for that hopeful message. We are going to bring young people into this conversation. We have a wonderful group of student leaders who have submitted questions and would love to pose them to you. So we're going to take a moment to transition and allow some of them to come forward and ask questions at this time. But I'm so honored that you have shared this time with us, your insights and your wisdom and your experience. So thank you, Justice Yacoob, and thank you, Anu. And I will invite the students at this time to participate in the next segment of the program. Okay, great. Thank you. Thank you, Justice Yacoob. Thank you, Anu. Welcome to the students then. We have a great lineup of student leaders and we're excited to take questions from them live. I'm going to start with Josiah Cohen. Josiah is a third-year student. He is an associate editor for the Colorado Law Review and a member of BALSA. He published a note on 10th Circuit qualified immunity and is interested in criminal defense. So Josiah, I welcome you to the program. You may ask your question now.
Thank you, Justice Yacoob. Such an honor to hear from you and be speaking to you. As you know, the term judicial activism is generally meant as a criticism of judicial decision-making, accusing so-called activist judges of legislating from the bench by resolving with attention to desired outcomes rather than strict adherence to the letter of the law. As you reflect on your career as a jurist in the wake of apartheid, what are your thoughts on the fairness and accuracy of that criticism? And do you think that criticism holds weight differently in the South African versus the US context?
Yes, I think the criticism is made by people who disagree with the decision. So the radicals and conservatives will accuse judges of being activists if they don't agree. In the end, I think that the criticism, so-called, is offside because judges generally, and even those that I disagree with, and there are many who I do disagree with, decide cases and try to decide them according to the Constitution and the law. And if the Constitution requires them to decide the case a particular way, it is incumbent upon to do it, whether they are called activists or not. Our Constitution is a little different in a way because it brings certain hidden assumptions forward. So, for example, Section 39 of our Constitution, as I have said earlier, makes it clear that we have to have regard to foreign law and international law. But more importantly, our Constitution says that if there are two possible interpretations of legislation, and the one interpretation is more consistent with the values of the Constitution, the values of dignity, equality, and freedom, and the other is not, then we must take those, or that interpretation rather, which is consistent with those values. What that does is it opens it up, and it doesn't make judges say, I'm going in accordance with the values. The Constitution now says to us that when you are in doubt and when you don't know which way to go, and you know that language doesn't mean the same thing to the same people, nor does it mean the same thing at different times. So I think that in the end, most judges try to comply with the Constitution, but the criticism of being activist is a broadside criticism aimed at attributing some other motive to the judge. And I think that 95% of the time it is not true. I think that even the most conservative judges in the United States of America, with whom I would disagree completely, are trying hard to do what they can do in terms of where they are.
Thank you. Thank you, Josiah. Our next student is Alan Jones. Alan is a first-year student, student government representative, BALSA member, and program director for the Silicon Flatiron Student Group. He's worked as a staffer for the United States Congress and is interested in tech law. Alan, your question?
Good afternoon, Justice Yacoob.
Hello.
In 2006, I had the opportunity to visit South Africa with my uncle, who's from Pretoria, and an anti-apartheid activist. While there, and only at the age of 11, I was disturbed by the 10 shack homes that were prevalent along highways and other open areas. This question is in regards to the group boom case. When you were drafting the Constitution on behalf of the ANC, were there any protections that you wish you had pushed to incorporate in the final agreement that would have prevented municipalities from neglecting their obligation to provide temporary emergency housing under Section 26? During negotiations, was it foreseeable that municipalities would fail to protect the inherent dignity of human beings?
The whole object of Section 26 was to ensure that housing was provided and there'd be a sense of dignity in the way in which it was done. And there was a judgment of the court, which I think you would have read, delivered in 1999. It may have been reported in 2000, called Grootboom, in which we set out the guidelines in relation to Section 26. And we made it plain in that judgment that there had to be a plan, there had to be an accessible plan. The people who needed housing most had to ensure that they had the most favorable treatment, that the dignity of human beings was very important in the process. But we could not have foreseen in 1999, I didn't, maybe others did, that corruption would overtake us all. So there has been a huge degree of corruption, which has taken away a lot of money which had been used for housing. And the difficulty is that officials in our country, and I suspect that that is so in many other countries as well, regard their housing portfolios as simply jobs. They do not have particular sympathy for people who live in desperate and difficult and poor circumstances. I thought that the officials in our country, because of where we came from, would be very different from officials I've come across everywhere in the world, including yours, by the way, including in your country, where there was a lack of caring for poor humanity. But unfortunately, I was wrong in thinking that. So firstly, there's a corruption. And secondly, there is no, well, let's put it this way, there is a marked absence of the feeling for human beings and the true empathy for poor people in officials who themselves were poor in the past, but they tend to adopt the attitude that because they made it, other people must make it too, and therefore they need no real help.
Thank you.
Thank you, Ellen. Our next student is Leonard Pollard. Leonard is a second-year law student. He is a White Center Fellow and president of the American Constitution Society and vice president of Outlaw. Leonard?
Thank you. Good afternoon / evening, Justice Yacoob. My question is, so over the past few years in the United States, there's been this successful effort to flood our federal courts with enormous numbers of conservative judges. And the most common justification for this is that the judges are apolitical, so that it doesn't matter that they're conservative because they're able to set aside their political leanings when they make a decision. Do you think that doing such a thing, like setting aside political or social or religious beliefs, is possible for a judge to do in making a judgment?
Yeah, I think it is that objectivity on the part of any person is absolutely impossible. So that the question is not whether judges are truly objective, because they can't be, and they shouldn't be, because you're not dealing with machinery parts and so on, or the repair of motor vehicles, in which a degree of objectivity is quite important. So firstly, a degree of subjectivity in judging is inevitable. But secondly, it is vital because you are judging human beings, and therefore you have to have some empathy and sympathy in the way in which you cast your judgments. So the question becomes not whether you should be subjective at all, but what is the right balance between your humanity and your subjectivity and your objectivity in a particular case? Because in the end, as an American judge has said, you can see things through no eyes other than your own, because your life has been shaped by what happens, instincts and a whole range of experiences which you don't even know about make you what you are. And judges cannot escape that tendency. And therefore we have to accept that to a degree, judges will bring themselves into the process. The only issue is whether they bring themselves too much into the process. And the problem is that if you pretend to be objective, you ignore the problem. If you are aware of it, as I was always, one of the difficulties is to ensure that you are not too subjective in the way in which you do things. And I suppose that as you get older, you do get more subjective. There was an article I read about Justice Stevens when he retired, when he was 80, in the Citizens case that he did. He, if the article was right, was so upset about the fact that that his opinion, which he thought was absolutely spot on, it was a qualification of freedom of expression, by the way, and he was upset that he was not in the majority in that case. And I'm glad I retired before I began to be upset about not being in the majority. So I think that the right balance is between, the right thing is the correct balance between objectivity and subjectivity. It's a complicated question. And I think that as you get older, the balance is a bit more difficult to manage. There is no such thing as absolute objectivity. And even if there were, absolute objectivity would result in inhumanity of the most horrible kind.
Thank you. Thank you, Leonard. I'd like to invite Neil Sandhu to ask a question. Neil is a third-year law student, a White Center Fellow. He's a member of the South Asian Bar Association and is interested in criminal defense. Neil?
Thank you, Professor Malvo, and thank you, Justice Yacoob, for being here. Justice Yacoob, today you spoke about your own internal struggle with racism. For those of us in the immigrant communities, we're often forced to reconcile not only with our own internalized racism, but the internalized racism of our elders. In your experience, what is the best way to confront the internalized racism of our elders, and what should our role be in helping them grow?
the best way is to understand why they are who they are. I must say, I used to find that easier when I was younger. Now, I get very impatient with younger people. Whether it's older people or younger people, the first thing is to understand why they are where they are. And secondly, to confront them. They have to be confronted, and they must be confronted very gently and carefully. I have to admit that my confrontation was very gentle and very careful 40 years ago. But as time went on, I began to get more and more impatient. But I'm sort of approaching a second childhood, I think, and might be getting to be a bit more gentle. But we have to talk to people about it. We cannot ignore the question. So apartheid had its interesting trouble for us. And an older person in my life who I respected greatly was very racist and thought that only African people in South Africa committed crime. And this person was very unhappy. Apartheid worked to my benefit because Chatsworth was an area where only Indian people lived in. And I said to her, look, I will take you to the magistrate court in Chatsworth, and you will see how many Indian people commit horrible crime. She wanted to dismiss me there and then, but I think that the point was actually made. But you've got to find imaginative, careful ways of making your point. But these things arise out of insecurity. Everyone's racism arises out of insecurity. And I have to concede that, and you might find this difficult, and you might chop me down for it, which I will understand, that even the racism of many white people, not all, but many white people, arises out of their own insecurity.
Thank you.
Thank you, Neil. Did you want to add something? I hear new. You're good? Okay. All right. I would like to invite the next student, Erin Vanek, to ask her question. Erin is a second-year law student. She's president of Outlaw, and she's a teaching assistant. She works on reproductive freedom issues, and she's interested in pursuing a career in LGBT plus law. Erin, please ask your question.
Thank you, Professor, and good afternoon, Your Honor.
Hello.
As you noted before, South African LGBTQ activists who are also active in the anti-apartheid movement played a significant role in shaping the post-apartheid constitution, making South Africa the first country in the world to explicitly protect sexual orientation from discrimination in its constitution. What lessons can be drawn from their struggle to achieve simultaneous racial and sexual orientation equality that could inform the current American gay rights and Black Lives Matter movements?
Thank you for that. I think I answered that question in an earlier question. And really the answer is that we have to talk to people and persuade them and get them to understand things well. You heard what I said, that it was when my daughter was born that I began to wonder what it would be like if she was lesbian, and that's what made me change my mind. So persuasion on a day-to-day basis is the only way, and you've got to find imaginative ways of persuasion. As I said earlier, bringing a case might be a good thing, but our Constitutional Court, for example, has said, as I said earlier, that gay and lesbian people should be able to marry. And yet 90% of South Africans, particularly church people, believe that gay and lesbian people live in sin. Oh, by the way, I hear that Pope Francis, I read in some newspaper this morning, said that he would champion the idea, not quite champion, but he would not be against the idea of gay and lesbian people being involved in what he calls civil unions. Of course, marriage is out of the question, but civil unions are fine. But I think that for the Pope of the Roman Catholic Church to say even that today in public is a huge advance. So we're very backward, but there are lots of advances. Persuasion, persuasion, persuasion. That is all I can say.
Thank you, Aaron. And now for our last student question, Essence Duncan. Essence is a first-year student. She is class president, volunteers with the Corey Wise Innocence Project, is a member of BALSA, and is a Lilac Fellow. She's a first-generation college and law student who wants to practice juvenile delinquency defense and civil rights. So, Essence.
Good afternoon, evening, Justice Yacoob. I feel so honored to get to speak with you today. Thank you so much for providing the lecture and just this opportunity for an open forum. To wrap up this question portion, I would like to ask about your definition of success. Your work, advocacy, and impact has been vast and worldwide, and I would just like to know how you truly define success, and do you believe that you have reached your own success in your career and in life?
That is the most complicated question of them all. And congratulations. I'm no philosopher, but I suppose success is to be ultimately happy about where you are. And if I were to talk about myself now, it is not that I was a judge. It was good to be a successful lawyer. It was good to make some money, but I was happy doing it. If I was unhappy doing it, and if I did cases in a way which I didn't like, it was a trouble. I remember coming back from a case, a rape case, where as gently as I tried to cross-examine the witness who was the victim, and I was very gentle with all rape victims, my client was acquitted. And I came back to the lawyer's common room very unhappy that my client had been acquitted. And they said to me, well, then you should become a judge. Being a lawyer is no place for you. So in the end, success is not success in winning a case. Success is about being ultimately happy about what you do. And I think you can never be happy with everything you do. There are always complications. But if you can be happy with more than half the things you have done, then I think you will do very, very well. Of course, it's not only a quantitative analysis, because you may be happy with 99% of what you've done, and then you may have killed somebody quietly somewhere, which does complicate the odds somewhat. But success is about happiness, about making a contribution to society, about fulfilling the societal contract and doing things that are good. And I say you must be happy because I'm the sort of person who disagrees with many things that society says is good. And that's why I don't think necessarily that happiness is about what society says is good. So you ask a very complicated question, and thank God the time available is short so that I can answer it in a very general way.
Thank you so much.
And for an atheist, I refer to God quite often.
Thank you, Essence. I knew she was going to ask the tough questions. We leave the best ones for last, so I appreciate that. And if the students could actually, if you can bring your screens up so that we can see you at this moment, I'd appreciate that as we're ending our program. Justice Yacoob, it has been such a treasure for you to give our John Paul Stevens lecture this year. I will add, I think Justice Stevens was 90 when he retired. So he might have something to say about your proposed age limit. It has been, such an honor, and we really needed your reflections right now. It's a hard time. So thank you for your words, your wisdom and your courage and your reminders how important it is for us to grow. I also want to thank Anu for being here, Anu for supporting us. Yes, please put your face in the screen so we can give you the proper due.
There we go.
There she is, supporting us, helping us with the technology in no small way. We really look forward to the day that you and Justice Yacoob can come and see us in Colorado for real, right? To come and be a part of our community. Yes, thank you. Yes, we are looking forward to hosting you. At this time, I'd like to thank all of the folks who worked really hard to make this happen. There's always a tremendous a group of villagers that we need to thank. I want to start with Yesenia Delgado, the events manager. She was our primary organizer, so I need to give her an amazing shout out. Thank you to Melissa Shenter, our faculty events coordinator. Thank you to Julia Roth, our director of marketing and communications. Thanks to the White Center Fellows, that's Lindsay Floyd, Neil Sandhu, Leonard Pollard. Thank you to our White Center faculty coordinator, Kelly Ilsang. And of course, as you mentioned, Justice Yacoob, our caterers, right? The IT staff who did all the magic in the background. So I really want to thank John Sabre, Teresa Coberly, and Nick Rusky for their tremendous work in terms of making this actually happen. I do want to thank everybody. We look forward to seeing you next year for the Stevens Lecture. And of course, it would not be a Constitutional Law Center if I did not say, please make sure to go out and vote. Thank you, everybody. And have a good night, Justice Yacoob and Anu.